The meeting of the Charter Commission's Rent Stabilization Work Group will now begin.
Good afternoon. Welcome to this virtual meeting of the Charter Commission's Rent Stabilization Work Group. This meeting includes the remote participation of members as authorized under Minnesota statutes, section 13D.021, due to the declared local health pandemic. The city will be recording and posting this meeting to the city's website and YouTube channel as a means of increasing public access and transparency. This meeting is public and subject to the Minnesota Open Meeting Law. For the record, my name is Peter Ginder, and I am one of the co-chairs of the Charter Commission's Rent Stabilization Work Group. I will now call this meeting to order and ask the clerk to call the roll so that we may verify the presence of a quorum.
Commissioner Perry.
Here.
Commissioner Rubenstein.
Here.
Commission Chair Clegg.
Here.
Co-Chair Sandberg.
Here.
And Co-Chair Ginder.
Present.
There are 5 members present.
I think I'm a member of the committee too. Is that right, Mr. Chair? That is correct.
You're a late addition and a
So,
welcome.
so I'm present also.
I apologize. There are 6 members present.
No problem.
Let the record reflect we have a quorum. We will now proceed to our agenda, a copy of which was posted for public access to the city's legislative information management system, which is available at lims.minneapolismn.gov. Commissioners, the agenda for today's meeting is before us. May I please have a motion to adopt the agenda?
Motion Sandberg.
Second.
Any discussion before the clerk calls the roll? Seeing none, I'll ask the clerk to call the roll on the motion.
Commissioner Perry.
Aye.
Commissioner Rubenstein.
Aye.
Commissioner Schwarzkopf.
Aye.
Commission Chair Clegg.
Aye.
Commission Chair Sandberg.
Aye.
And Co-Chair Ginder.
Aye.
There are 6 ayes.
That motion passes and the agenda is adopted. Commissioners, there are minutes from our regular meeting on March 3rd, 2021 that need to be accepted. May I have a motion to accept the minutes?
Motion Sandberg.
Second, Clegg.
The motion is before us. Is there any discussion? Seeing none, I'll ask the clerk to call the roll on the motion.
Commissioner Perry.
Aye.
Commissioner Rubenstein.
Aye.
Commissioner Schwarzkopf.
Abstain.
Commission Chair Clegg.
Aye.
Co-Chair Sandberg.
Aye.
And Co-Chair Ginder.
Aye.
There are 5 ayes and 1 abstention.
That motion passes and the minutes are accepted. Item 4 on the agenda is the chair's report, and I have just a couple of things to mention briefly. One is a reminder that we need to finish all of our work in order to present our recommendation to the July Charter Commission meeting, or otherwise we will be calling a special meeting for the Charter Commission. So I would like to see if we can do that before that July meeting. And so I know we waited 3 weeks almost to have this meeting in order to give people time to review our legislative file, as well as for the city attorney to do her work on questions were submitted to her. So I hope we've had an opportunity to, one, to do some review on the legislative file that's been accumulated. And I know that we're prepared to at least have some of the city attorney's opinions being discussed tonight. The second item I will mention is that I had been in contact with Professor David Schultz from Hamline University about the possibility of him speaking on the initiative and referendum issue. Unfortunately, he teaches the class at this same time, and he won't conclude that class until after May 18th. And so I don't want to call a meeting outside these times because I know it's a time that's acceptable to all the members. as well as I don't need to put any additional burden on the clerk's office with finding new times. So I'll hold that to see where we are after the next meeting or so. But I will say that he did provide us a law review article that addresses the initiative and referendum question that's in the legislative file that I'm assuming would cover much of what he would discuss. And finally, before we get into this, which will also segue into our next agenda item, is remember that there are two different items before us. One is the initiative portion of the amendments, and the other is the referendum portion of the amendments. And so there are two things to kind of consider as we move forward on this matter. So anyway, unless there are any comment on the chair's report, I would move into discussion item 5.1. And seeing no discussion on the chair's report, item 5.1 is considering amendments to the charter proposed by the City Council, adding the initiative and referendum for the sole purpose of exercising the city's authority to control rents and private residential property in the city, and explicitly adding the city's authority to exercise power to control rents and private residential property in the city. So with that, is there any discussion?
Mr. Chair.
Commissioner Schwartzbach.
As I read this, the last, on the second page, which is what, number 5, I guess it is. Number 5G and G2, it's submission to voters. It says the council may submit a rent control or rent stabilization question. As I read the law, which permits to happen, it says that they must, or that the voters got to vote on it. So if they don't send it to the voters, then the voters can't vote on it, therefore nothing can happen. So should the word be may or should the word be must?
Well, that's, Commissioner, is a question that kind of was submitted to City Attorney Bashoon, and she can certainly address that. But I think, as I understand the answer, it's not fully clear, because arguably under the special law, or excuse me, under the law that provides for rent control in the cities, for a city to do it, it has to be approved at a referendum. And the argument on the one side is that by voting on the proposed amendment, that is the requirement that is required by the statute. The amendment giving the City Council the authority to create rent control. And if I understand Ms. Bashoon correctly, that the second part of that, where they may submit it to a vote, is have the clarification in the event that the law is the other way. If there was a challenge, that they would then move forward to put it on as a referendum to the full vote, to the voters. I don't know if that does justice to Ms. Bashoon's analysis, but that is what I kind of understand with some other discussions with her.
Well, the referendum is the next one you're going to talk about, I think. And I run into the same problem on the referendum, which I don't know if you want me to bring up now or bring it up when you discuss that one.
What I might propose is delaying that until after we've had the city attorney's report on item 5.2 and get some further explication from her on that issue.
Very good, thank you.
Commissioner Rubenstein. It appears you're muted.
Right, sorry. It appears that some of my questions are the same as Commissioner Schwartzkopf, so I will hold off and wait for the city attorney to speak. But I did have one other question, and that is, in reading all the materials that you or others kindly submitted to us, there was somewhere a reference to the fact that the legislature is considering legislation that would prevent us from doing what we're doing. And I wondered what the status is of that legislation, if you know.
Commissioner Rubenstein, I do not know the status of that proposed legislation. I don't know if anyone else does. but I do not.
Thank you.
Is there any other discussion on the proposal for adding initiative and referendum to the city's charter at this time? I don't see any hands raised on that or on the part 2 of that. So I'm moving to part 2. I don't know if there's any further discussion on anything under item 5.1. Seeing none, I'm going to move to item 5.2 on the agenda, which is receiving an update from the city attorney's office. So Ms. Bashoon, I would turn this over to you at this point. You're on mute.
Thank you, Co-Chair Ginder. Yes, I think I'll start by addressing some of the questions that have been brought up. With respect, and I'm going to first talk about section 4.1. Under section 4.1, for the rent stabilization, there are 2 provisions under there, G1 and G2. Vice Chair Ginder, as you were stating, you know, it's really set up to be 2 options. The first is that the City Council would adopt a charter amendment that would allow the City Council to have a rent stabilization ordinance. So once it is approved by the voters, then the City Council could come up with their own version of an ordinance for rent stabilization. The second G2 provides for the submission to the voters. Now this would be an alternative that the City Council could use. The actual statute, Minnesota statute section 471.9996 allows rent control as long as the statute is followed, but the statute is not very clear. So it's possible that it could be read to say that once a charter amendment allows the City Council to create an ordinance, then the City Council can create the ordinance. Others may say it's unclear that even the ordinance after it's approved after it's allowed under the charter, that maybe an ordinance has to be submitted to the voters. So the second provision, the submission to the voters, is just in there in case a court would come back and say that we do need to submit something to the voters. So that's why that's there, and that's why it says the council may submit a rent control or rent stabilization ballot question to the voters, because initially it's believed that just having the ability in the charter for the City Council to create an ordinance is enough. So the submission to the voters would be something in addition to that. And the City Council could also say, well, we want to submit it to the voters anyway, even though it's in our charter. We just want the voters to be on board. So that is why the amendments to 4.1 is written that way. I also want to discuss some errors that were brought to my attention by Vice Chair Ginder. There are some errors in the drafting of the 2 ordinances, section 1.4 and section 4.1. I'm going to just generally tell you what those are, and then I will provide some proposed revisions to the work group. We were first talking about section 4.1. That is when the charter would be amended to allow the City Council to adopt a rent stabilization ordinance, or to submit it to the voters at some later point if they wanted to. There is language on the submission to voters that it does talk about submitting the vote to the general or to a general or special election. And the statute only allows one option, which is to submit it at a general election. Typically, we're allowed to submit questions to voters at general or special election, but the statute 471.9996 only allows the option of a general election. So I will be providing some language that states that the vote submission to the voters would be at a general election. So I would be taking out language, the or special, and also the language on a date allowed under Minnesota election law. So if in fact, and the reason I would take out on a date allowed under Minnesota law or recommend that, it's because basically special elections are now allowed only on specific dates of the year. And that's a fairly new statutory requirement. So basically that second sentence under submission to voters, I would recommend that it read, it must be submitted at a general election period. And I can provide that recommended language. I know this the Charter Commission has the ability to submit a substitute amendment. And if that is the route that the Charter Commission wants to go on this, I would recommend that those changes be made to fix those errors. On the other 1.4, I want to mention that that same error is in 1.4, in that it does state that an amendment would be submitted to a general or special election. Again, I would take out the language that relates to a special election. And there's also one other error. If there is a petition, if this is allowed, if there is a petition, an initiative petition, and it meets all the technical requirements, then the city council would have to take action on it. The language provides that there could be 3 actions. However, there should only be 2 actions that the city council can take. One of the actions that the city council can take under the language is to enact the ordinance without change. Some initiatives allow an ordinance that's submitted by the voters to be approved without change. However, the statute related to rent control 471.9996 only allows an ordinance such as this, like through a petition, an initiative petition, to be approved if it's sent to the voters. So I would recommend that under 5AI that be eliminated as an option. So those would be my changes if in fact the Charter Commission wants to propose substitute amendments, and I can provide you, I will provide the co-chairs and Chair Clegg with that proposed language in case the Charter Commission wants to submit substitute amendments. And unless you have any further questions on that, I just want to go to the another question that was proposed by Vice Chair Ginder, which is, can we have an initiative authorization where there's only one type of initiative that can be had, and that would be only for rent control. I can go through that unless anybody has any questions on some of the changes. Why don't I go through that? I did research on whether or not the city can propose that the charter be amended to allow only one type of initiative. That would be one for rent control or rent stabilization. The statute that applies is 410.20 that statute is couched in terms of the term may, that the city charter commission may amend the charter to allow initiative by the voters of Minneapolis. It doesn't specifically state that the initiative has to be for all topics, and it doesn't specifically state that the initiative can be for one topic or more than one topic. It just is couched in the terms of may. 410.20 is in chapter 410 of the Minnesota statutes. 410 lays out the ability of the city to be a charter city. It lays out the ability of a charter city to really run its government in the manner in which it wants to run. It provides that, one second. That 410 really provides that the city through a charter can have any scheme of government that it wants, as long as it's consistent with the Constitution, the state law, and the state policies. So that's very permissive. It allows a lot of leeway for the city to set up a charter and to run its own government. That language in chapter 410 is in sync with 410.20, which is again permissive, that it allows the city to set up an initiative. I did not see any specific cases in Minnesota that talked about what a situation where one city set up an initiative for only one topic. I didn't see any kind of challenge related to that. However, I'm looking at more so statutory construction. Under statutory construction, the language is very permissive, using the word may. It doesn't specifically limit the ability of the city to say that they only want initiative on one particular topic. Therefore, I think it is permissive for the city charter to allow an initiative only for one particular topic. That would allow the city council to be able to allow initiatives and/or basically the voters to submit ordinances for rent control, but not on other topics. And that makes sense, that the city should be able to limit and decide how much the voters should be able to get involved in creating and setting forth ordinances for the city. And also, while it is in Alaska, I know that in Alaska they do have voter initiative, but they have limitations on it. They have limitations under the Alaska Constitution. The state law in Alaska also has the similar limitations. And then also the Anchorage, Alaska charter has limitations on voter initiatives. So voter initiatives can be used, but there are certain topics that are prohibited from voter initiatives. So, I mean, from my research and using statutory construction, it's my legal opinion that there can be a voter initiative in the city of Minneapolis charter that allows the voters to use the initiative power only for one purpose, and that would be for the rent control purpose.
Thank you, Ms. June. I see that Craig has his hand.
Yes, thank you for your report, Ms. Bashoon. Is your opinion also that referendum may be limited to one purpose?
Ms. Bashoon, you need to turn your mic back on.
I can't.
There, whoops.
Okay, now I can. Okay, yes, it's the same language. It's the same language in the statute. And I think that could be the case. I can let you know that the case law talks about initiatives, and it talks about not when there's an initiative, it means you can change, you can create a new one, you can create a new ordinance, or you can revise or repeal an ordinance. So initiative covers all of those. But if you're asking about a referendum, yes, I would think that would be the same argument, that the language in 410.20 is very permissive. And let me just double check. Sorry about that. Let me just check the statute real quick. Thought I had it right here. I know.
You did cite it in your opinion.
Yeah, I'm looking at it now. Thank you. Let's see. Yeah, with the referendum, and the statute couches provides that the referendum listed here is that if you wanted to, that no ordinance would be passed by council. You could state that no ordinance would go into effect unless it would be sent to the electors for their vote. And in that language, it also says may also provide. So I think all of the language in 410.20 is couched in the may term and is permissive.
Are there any other questions for Ms. Bashoon on this topic? I don't see anyone's hands raised. I would just say that I did some modest research myself on this topic, and I have not located anything that would cause me to have any disagreement with Ms. Bashoon's opinion. The discussion does raise a point that I've thought about in recently, and it goes along with the substitute motion that Ms. Bashoon is proposing that she would prepare and send to us. And I would, again, as I mentioned earlier, we have an initiative amendment in front of us. We have a referendum amendment in front of us. And something that I thought of the other day is if we want to send back a substitute amendment, it doesn't necessarily have to include both of those. It could include one or the other. For example, if this body deemed initiative to be something we didn't want to go forward with, we might also consider with whether or not referendum is something different. And the reason I bring that up is that if you take out the Minnesota statute governing rent control, what that really did was it took legislative control away from all the city councils and city legislative bodies, which they would normally have had. And if one thinks of it that way, by putting in a referendum that would allow the city council to pass rent control subject to a referendum, basically what you've done is given back the authority that the legislature took from them. And I bring it up because I also think it's interesting in our other amendment that is going forward on our executive, mayor, and legislative council, that there is some fit with that. I'm throwing that out there. I'm not advocating one way or another, but I'm just, as we think about this going forward, I'm just throwing it out. And seeing no further discussion on this topic, I see Ms. Rubenstein has her hand up.
Yes, Mr. Chair, just a clarification. As I understand what you were just saying, the city already had that authority to submit a referendum to the public, but we've never had an authority to permit initiative.
Let me rephrase that. The city has never had referendum authority or initiative authority going back to the 1860s. What the city council had on its own, all the broad policymaking power that a city legislature would normally have. So for example, when they passed the paid sick or minimum wage, those are exercises of that general legislative / police power. rent control, in the absence of this statute, would have been something that the city council could have done by ordinance on its own. But since the legislature took that power away, it now can only be exercised after there is some form of referendum or initiative giving that power back to the city council. And so that's kind of more, I guess, a better explication of what I'm kind of throwing out.
Thank you. So you're not differentiating initiative and referendum at this point, just what the police power is.
The police power, the city council would have had the power to do this. And there are two ways in the statute of doing it. One is by initiative, and the other is by referendum.
Okay, thank you.
With no other discussion on that topic, the next item is considering whether to set a public hearing on the proposed charter amendment. And is there any discussion on that matter? Commissioner Perry.
Thank you, Co-Chair Ginder. Yes, I advocated for, at their last meeting, I advocated for a public hearing on this item, on these items before us. I realize that there already has been a public hearing by the city council, and I also realize that people may not stick to the actual issues before us, but I would argue that for purposes of transparency of the commission, that we hold a public hearing on these items and give people the opportunity, the chance to voice their opinion on the subject matter before us as a commission. And not doing so, I think, makes it look like we are being secretive and working behind the scenes. And I don't want that to be, we're obviously not trying to do that. But I think by not having a public hearing, it gives the appearance that we are trying to do that. So I would strongly advocate for a public hearing on both of these amendments.
Thank you. Commissioner Sandberg.
Thank you. I understand what Commissioner Perry is saying, and I did listen to the other public hearing, and it all focused on the desirability of the council making changes to affect rent control. I would be very interested in a hearing on the initiative component. Unfortunately, I think there's no way to practically do that to separate all the issues. And I think that we would be getting into a hearing that would focus on that people want rent control, not whether the city council should have the ability. Having said that, I understand his issues about transparency and so forth. So I'm not sure what it would get us in terms of making a decision, but there may be other factors. So I'm still thinking anyway. Just a thought.
Chair Clay.
Thank you. I don't think we need another public hearing. This is a council proposed amendment, not a charter commission proposed amendment. So our rules don't require a public hearing. And the council has already held a public hearing. It's their responsibility to do so, not ours. We held a public hearing with the public safety amendment, not because it was a council proposed amendment, but because the council asked us to do so. They did not have the time to hold a public hearing and they asked us to do so. I don't think we should let that be a precedent. If a council proposed amendment should be considered by the council after public hearings in front of the council, not by the Charter Commission.
Thank you, Chair. Commissioner Rubenstein. Your mute button is on, Commissioner.
Sorry. If we offer a substitute amendment, as Ms. Bashoon has just suggested, and which seems quite desirable, I guess the substitute amendment would really be more technical than substantive, from what I can tell. But in any event, if we do offer a substitute amendment, does that change our obligation?
Before I call on Commissioner Perry, I'm going to just weigh in at this stage since he's spoken once. First, to answer Commissioner Rubenstein's question, my answer is no, I don't believe it does, because the topic is the same. There would be no change in that. But I am also opposed because under our rules, we would not normally provide a public hearing on this kind of a matter. Two, we've been fully transparent on all of our meetings, in addition by creating our own legislative file on this that not only has the rent control in it, but also initiative and referendum material, so that we've been fully transparent on what we've been gathering. And also with the final point that Co-Chair Sandberg raised is that would be an impossibility of trying to have the nuance that this would only be a public hearing about initiative and referendum and not the subject matter of rent control, and we would not be able to control the meeting in that regard. So I would be opposed, but I'll now go back to Commissioner Perry.
Thank you. So I recognize the points of the fact that it would be difficult to control what people are talking about, but I think they could be encouraged to discuss the subject matter at hand. I do think, though, that if we are in maybe it's not in our rules, but I think if we are in a position where we're going to reject, accept, or even put forward a substitute motion or proposal, that we ought to give the public an opportunity to speak on that, even if it's in a technical nature.
Is there anyone else speaking on this issue? I don't see anyone else. Is there any other discussion on this issue? Seeing none, I believe we've concluded our agenda. I will shortly discuss with the co-chair the schedule of our next meeting. And as I indicated earlier, I think we want to try and keep this moving in light of everything else that's going on with the Charter Commission. But with that, we've concluded what was to come before our rent stabilization work group. And without objection, we will now stand adjourned.